Distinction between the property owner having a dispute with the state under administrative codes versus a dispute with my client in common law are very different things, and it does not protect the property owner if he or she has a permit. That grandfather clause does not protect them from liability, not in my state. So again, grandfather protects against the taking of it on one hand, but it does not protect you in a common law scenario where the owner knows or should know of a dangerous condition. Now that's an important concept to grab onto, the know or should know. The driveway that my client on her motorcycle was injured in was built in 1969, well before New Jersey even had an access code or a real significant permitting process. So when we did have our access code, that driveway was grandfathered in, which meant that they didn't have to move it unless the state said they had to move it. And so they let it sit within a functional intersection, left turns in, left turns out, conflict points all over. They knew it was dangerous. This is a huge corporation that owned this property. Knew it was dangerous, but they didn't upgrade it because they said, we're grandfathered in, we don't have to. But accidents were happening over and over again, left turn in, left turn out. And just 6 miles up the road, that same corporation in 2000-ish built another convenience store and tried to put a driveway with left turns in a functional intersection with no control measures. And the state DOT, by that time we had a permitting process, stepped in and said, you can't do that, it's dangerous. Shut it down. There were public meetings, and I have the transcripts, where this corporation and its lawyers and its engineers appeared, and they got screamed at by the borough people that said, left turns in functional intersections with no controls are dangerous. State says so, you're not allowed to do it on this new project you're building. So they conformed to the current standards in 2000-ish. But what did that mean? It meant that 6 miles down the road, the same configuration that had been dangerous since the 60s, they let it sit because they said, well, we're grandfathered in. So we know it's dangerous in present day, but we're going to leave our old stores that are dangerous, we're going to let them sit because we've got this grandfather clause. Not going to work. They had notice of what was dangerous decades before, and they let it sit. Accidents kept happening, and my contention is they're going to be at fault for that.